Judgment in the matter of Akbars Restaurant against Secretary of State for the Home Department.
As part of the suite of measures for the control of immigration, statute provides for financial penalties to be imposed on employers who employ immigrants who do not have permission to be in the country or who do not have permission to work here. Such a penalty is imposed by means of a civil penalty notice issued by the Secretary of State for the Home Department directed to the alleged offending employer. The employer is given a right of appeal to the county court. The penalty notice regime is set out in the Immigration, Asylum and Nationality Act 2006. Section 15.1 provides that, quotes, "It is contrary to this section to employ an adult subject to immigration control if A, he has not been granted leave to enter or remain in the United Kingdom, or B, his leave to enter or remain in the United Kingdom is invalid, has ceased to have effect, whether by reason of curtailment, revocation, cancellation, passage of time or otherwise, or 3, is subject to a condition preventing him from accepting the employment." It's important to note that these limbs are mutually inconsistent. This appeal is concerned with the information which has to be set out by the Secretary of State in a penalty notice issued by her. Section 15, subsection 6A, is the provision which is central to this appeal. It provides that the penalty notice, quotes, "must state why the Secretary of State thinks the employer is liable to the penalty," close quote. The questions which arise on this appeal are whether the Secretary of State has a statutory obligation to state which limb of Section 15.1 applies, which justifies the service of a penalty notice, and, if there is such an obligation, what is the consequence if she fails to comply with it? The Appellant is a company which operates a restaurant in Middlesbrough. In January 2023, immigration officers conducted an inspection of the restaurant. They identified one worker who they believed was an immigrant working in the UK illegally, his leave to remain in the UK having expired. The Secretary of State issued the appellant with a civil penalty notice for a penalty of £15,000. The notice stated that the reason for the penalty was that the appellant had employed someone subject to immigration control who has, quote, A, not been granted leave to enter or remain in the UK, or B, their leave to enter or remain in the UK is invalid or has ceased to have effect, or C, who is subject to a condition preventing them from accepting the employment in question, close quote. In other words, the penalty notice listed all 3 limbs in Section 15.1 without stating which one the Secretary of State thought applied in relation to the worker. The appellant appealed to the county court against the penalty notice. The appellant submitted that the penalty notice was invalid because it failed to specify which limb of Section 15.1 the Secretary of State thought was applicable and therefore did not comply with the requirement in Section 15, subsection 6A. By the time of the hearing of the appeal, the Secretary of State filed evidence to indicate that in fact she thought it was the second limb of Section 15.1 which applied, namely the worker's leave to remain in the UK had expired. The county court judge dismissed the appellant's appeal and held that the penalty notice complied with the requirement in Section 15, subsection 6A, even though it did not specify which of the 3 limbs in Section 15.1 was thought to apply. The appellant appealed to the Court of Appeal, which dismissed the appeal. The appellant now appeals to the Supreme Court. The Secretary of State submits that, as held by the courts below, the penalty notice complied with the requirement in Section 15, subsection 6A. In the alternative, the Secretary of State submits that even if that statutory requirement was breached, the county court was still right to dismiss the appellant's appeal against the notice because by the time of the county court hearing, the Secretary of State had explained which limb of Section 15.1 applied. The Supreme Court unanimously allows the appeal. In order to have power to issue the penalty notice, the Secretary of State had to decide which of the 3 mutually inconsistent limbs in Section 15.1 she thought was applicable in the appellant's case. Section 15, subsection 6A, required that she state in the penalty notice why she thought that the appellant was liable to pay a penalty. According to the natural meaning of that provision, this clearly meant that the Secretary of State had to state which of the limbs of Section 15.1 she thought applied. This she failed to do. Accordingly, she failed to comply with the statutory requirement in Section 15, subsection 6a. The Court also refers to features of the context in which Section 15, subsection 6 applies, which strongly support that interpretation of it. Among other things, fairness requires that such information should be given in the notice. A penalty notice should inform an employer which limb of Section 15.1 the Secretary of State is relying on, so that the employer can know why the state is imposing a heavy fine on them, and so they can make an informed decision about whether they have grounds for an appeal or not. The Secretary of State's fallback argument was that it didn't matter that she had breached her statutory obligation to state proper reasons for imposing the penalty. The Supreme Court rejects this argument. For the reasons already referred to, Parliament must be taken to have imposed the obligation as one which it was important for the Secretary of State to comply with. A person subject to a penalty notice should not have to appeal in order to find out the true reason why they are being subjected to a heavy fine by the state, and in order to be able to make an informed assessment of whether they have a good ground of appeal. Parliament intended that if the Secretary of State failed to comply with the core obligation on her to explain in the penalty notice her reasons for imposing the penalty notice would be invalid. Therefore, the County Court should have allowed the appellant's appeal to it in this case, and it follows that the appellant's appeal to the Supreme Court should be allowed.